So today we're going to cover, just jump right into the new laws for 2025 and discuss those. Fortunately enough, there aren't any major laws impacting California employers like we've had in the past years. It's a relatively easy year for California employers. And on top of that, we did get the PAGA reform, and I'm going to touch on that a little bit towards the end too, if time permits. So overall, it's a pretty good year for California employers on the legislative front. So that's the good news. There are a few things employers need to be aware of, and we'll cover that and update some handbooks and policies, but it's really on the fringes, nothing major that is going to really have to change like an employer's operations here in California with the new laws. We're going to talk about some cases up at the California Supreme Court as well that we're keeping an eye on and what those mean for employers in 2025. And then we'll review a few key dates as we come into 2025 to keep your eye on that as we progress through the year. And then just a few reminders. We're going to touch base. There's a lot of development, especially for the restaurant industry in 2024. So we're going to go back and just review 2024 on a few key things that apply to restaurant operators here in California. So we'll cover that as well. And it's all in the slides, and we will be making these available, as I mentioned, through Jackie. And if you have any questions, feel free to pose those through the software here through Zoom, and we'll do our best to circle back on those questions. And Jackie, I think you'll help on that too. Keep an eye on that. That'd be great. So jumping into it, this new law, AB 3234, that was approved back in September, it takes effect January 1st, 2025. For companies that are doing these social compliance audits, it's voluntary right now, at least for right now. These are voluntary. Employers don't have to do these. But if they're doing these social audits, this law requires them to post certain information on their website, reporting back certain details about the audit, details about child labor, written policies, things like that. So if the companies are putting themselves out there as being, certified through these audit companies, and it's all voluntary at this point, then you need to explain what's going on, kind of the details behind that, and put a link on the website. So again, not mandated, but do keep your eye on this going forward. Unfortunately, I'm thinking California, this might be something that turns into a mandate in the future, and this could be the roadmap for what may be required in the future. But keep your eye on it. And, if you're not doing these social compliance audits right now, no need to do it. It's not legally required or anything. It's just one of these voluntary steps right now. So if you're not currently doing that, engaged in that, there is no need to start looking into that. But if you do, it's important that you comply with this new law. This next one, I believe we're passing over to Anne.
Thanks, Anthony. Good morning, everybody. So there's two new poster requirements for California employers starting January 1. I'm going to talk about the whistleblower postings. Current law required employers to post a list of employees' rights and responsibilities under California's whistleblower laws. While the California Labor Commissioner provides a sample notice, in that notice, it says, oh, this doesn't guarantee compliance with the poster requirements under the Labor Code. Now, with Assembly Bill 2299, the Labor Commissioner is required to develop a model notice regarding employees' rights and responsibilities under the whistleblower laws. If you use that poster, it will be deemed to be compliant with the law. The new poster will be available on the Labor Commissioner's website. We've got the current poster link in this slide. And a quick takeaway on this is whether you use, the individual posters or the combination all-in-one poster, this is the time to start planning for what you need for your 2025 posters. Remember, if a governmental entity comes into your premises for any reason to inspect, one of the first things they're going to look at is, do you have all the required postings prominently displayed where the employees can see that? So this is an easy one to comply with. And we can move on, Anthony, to the next slide. So Senate Bill 399, the California Worker Freedom from Employer Intimidation Act, will prohibit employer mandated meetings. Sometimes we call those captive audience meetings, in relation to a union's organizing effort, or in which an employees are required to attend and listen to the employer's opinions about religious or political matters, including the decision to join or support a labor organization. This prohibition also applies where an employee declines to receive or listen to any other type of communications about the employee's opinions on political or religious matters. The law is very clear that you cannot take any adverse action against an employee who fails to attend one of these meetings. Employers cannot subject or threaten to subject an employee to discharge, discrimination, retaliation, or any other type of adverse action because the employee declines to attend the employer-sponsored meeting or declines to listen to any other communication regarding the employer's opinions about religious or political matters. This new law can be enforced in a private court action, or it can be enforced by the labor commissioner. Damages are available, including injunctive relief, and employers who fail to abide by the law are subject to a penalty. I will note that there is likely going to be legal challenges to this new law on the grounds that it violates an employer's right to free speech under the U.S. Constitution and/or is preempted by the federal National Labor Relations Act. So we'll be keeping an eye on any legal challenges or clarifications on interpretations on this new law. And a quick takeaway, because the bill prohibits employers from requiring employees to attend mandatory anti-union meetings, employers should be cautious and consider having it a voluntary meeting instead, where you're educating employees regarding union activities and campaigning. But if an employee declines to participate, remember that they should be paid for their time during the meeting and no adverse action directed toward that employee. And I think next, I'm going to pass it along to Yaron.
I'm actually going to jump in for AB 2499. Thanks, Ann. So this new law prohibits discrimination against victims of violence. It's modifying the existing laws. So just to back up a bit, prior California law provided protections to employees from discrimination or retaliation for taking time off for jury duty, court appearances, or to employees who are victims of crime or abuse. So under AB 2499, employees still have these same protections, but the law broadens the definition of victim a bit and what these qualifying acts of violence are. So qualifying acts of violence are defined as any of the following items, regardless of whether anyone is arrested for, prosecuted for, or convicted of committing any crime. So these qualifying acts of violence are domestic violence, sexual assault, stalking, and any conduct or pattern of conduct for any of the following: an individual causes bodily harm or death to another person, an individual exhibits, draws, brandishes, or uses a firearm or other dangerous weapon with respect to another individual, or an individual uses or makes a reasonably perceived or actual threat to use force against another individual to cause physical injury or death. So it broadens this definition of victim and the qualifying acts of violence. So important to note here is that it doesn't require anyone to be arrested or prosecuted, even prosecuted or convicted of any of those. It's just whether they are a victim of that violence. The law also removes the jury, court, and victim time off provisions from the labor code and moves it over to the California Fair Department and Housing Act under the government code section. And so this provides enforcement by the California Civil Rights Department under this new law. So we may see increased enforcement from the CRD here going forward. The new law also requires that employers permit employees to use vacation, personal leave, paid sick leave, or other paid time off that the employee has available for this leave, qualifying leave under this new law. And then finally, employers are required to provide written notice to employees of the rights under this new law to all employees annually. And at the time, and if requested by any employees, needs to be provided to them. And at any time, the employers become aware that the employee may need this type of leave. So important to update those notices. And I did see Jackie posted a link that the CRA does have compliance posters and yeah, these types of notices that need to go out to the employees. So something to note on that. And just again, a minor tweak. This is something we're looking at for employer handbooks as we update those going into 2025. With that, I'll hand it over to Yaron.
Thank you, Anthony. Good morning to everyone. So we're going to continue with the what you'll see is a trend on discrimination. Many of the things that are new to 2025 seem to arise out of or relate to discrimination. SB 1100 is no different. So by way of background, California Fair Employment and Housing Act, also known as FEHA, prohibits various forms of employment and housing discrimination, including discrimination based on national origin. So in 2013, the California Department of Motor Vehicles was authorized to issue driver's licenses to undocumented immigrants who provided proof of their identities and California residency. A year later, in 2014, FEHA was amended to make it a violation for an employer to discriminate against individuals with these types of driver's licenses. In other words, licenses issued to undocumented workers. And this type of discrimination was considered a form of national origin discrimination. As explained in the legislative history for SB 1100, a driver's license is irrelevant to most jobs, and requiring a driver's license disproportionately impacts people with disabilities, low-income individuals, and those living in urban areas with access to public transportation who choose not to drive or own a vehicle. And with that, SB 1100 was born. So SB 1100 becomes effective January 1, 2025, and adds to the list of prohibitions under FEHA, making it an unlawful employment practice for an employer to include a statement in a job advertisement, posting, application, or other material that an applicant must have a driver's license, unless, of course, two conditions are satisfied. Those two conditions are: one, the employer reasonably expects driving to be one of the job functions for the position, and two, the employer reasonably believes that satisfying the job function using an alternative form of transportation would not be comparable in travel time or cost to the employer. When we're talking about alternative forms of transportation, that term is defined as to include but not be limited to using a ride-hailing service, using a taxi, carpooling, bicycling, and walking. Okay, next slide. SB 1340. So this bill specifies that nothing in California Fair Employment and Housing Act limits or restricts efforts by any city and county, or other political subdivision of the state to enforce local anti-discrimination laws if the following 4 requirements are met. So 1, the local enforcement concerns an employment complaint filed with the CRD, or the Civil Rights Department. Requirement number 2 is that the local enforcement occurs after the CRD has issued a right to sue notice. This is typical with, you may be familiar with right to sue notices with the CRD and other agencies related to other forms of discrimination. So this is no different. Requirement number 3 is that the local enforcement commences before the expiration of the time to file a civil action specified in the right to sue notice. And then lastly, that the local enforcement is pursuant to a local law that is at least as protective as the FEHA. So the law requires that the department, the Civil Rights Department, to promulgate regulations governing local enforcement pursuant to those provisions. What this means is local agencies may now play a more active role in handling discrimination complaints, potentially providing quicker and more localized responses, and it opens employers up to a patchwork of discrimination laws at the local level. Continuing our tour of discrimination-related changes for 2025, SB 1137. So under California's Unruh Civil Rights Act, FEHA, and provisions of the Education Code prohibiting discrimination in public education, existing laws provide that all persons are entitled to full and equal accommodations, regardless of their sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, sexual orientation, citizenship, primary language, or immigration status. Existing law defines these protected characteristics as including a perception that the person has any particular characteristic or characteristics within the listed categories, or that the person is associated with a person who has or is perceived to have any particular characteristic within these categories. SB 1137 clarifies these laws that prohibit discrimination not just based on one protected characteristic, but based on the combination of 2 or more protected characteristics. In other words, the law amends FEHA to clarify that the protected characteristics enumerated in the statute include a combination of those characteristics. While California laws have long prohibited discrimination and harassment based on protected characteristics, they now also apply to this new term, intersectional identities, where 2 or more characteristics result in a unique form of discrimination. The bill's author, California State Senator Lola Smallwood Cuevas, noted in a press release that discrimination transcends singular dimensions, and this bill is common sense reform that addresses the intersectionality of discrimination cases, providing greater protections for Californians, especially those from our most marginalized communities of color. Let's move on to the next slide. Again, this is related to discrimination, and in this case, hairstyle. AB 1850. This bill expands the definition of race in the anti-discrimination provisions of the California Civil Code, Government Code, and Education Code. So under the amendment, the term historically is removed from the definition of race, where it used to say it's inclusive of traits historically associated with race. It now removes that, the term historically. And the definition is now inclusive of traits associated with race, including but not limited to hair texture and protective hairstyles. The bill now adds a definition of protective hairstyles to include but not be limited to such hairstyles as braids, locks, and twists. Next, we have AB 2123. And this is concerning disability compensation under the paid family leave program. And so here, existing law establishes within California's state disability insurance program, also known as the paid family leave program, for the provisions of wage replacement benefits to workers who take time off work to care for certain seriously ill family members, to bond with a minor child within 1 year of birth or placement, or to participate in a qualifying exigency related to covered active duty or a call to covered active duty of certain family members. And existing law authorizes that an employer can require an employee to take up to 2 weeks of earned but unused vacation before and as a condition of the employee receiving paid family leave benefits. AB 2123 makes that authorization inapplicable to any period of disability commencing on or after January 1, 2025. In other words, effective January 1 of next year, employers can no longer require employees to use accrued vacation before accessing eligible paid family leave benefits. This is again, one area where it will be important for California employers to take a look at their policies and their handbook as it relates to, their leave benefits, and if they have been mandating requiring the use of accrued vacation before providing these benefits or making these benefits available to employees, that needs to now change. All right, next. AB 1870. So this is relating to workers' compensation and a posting notice to employees. As Ann touched on, there's a couple of posting requirements for 2025. This is among them. So existing law establishes a workers' compensation system to compensate an employee for injuries sustained in the course of employment. I'm sure you all are very well aware with our system. Employers who are subject to the workers' comp system are generally required to keep posted in a conspicuous location, frequented by employees and easily read by employees during the hours of the workday, a notice that includes, among other information, to whom injuries should be reported, the rights of an employee to select and change a treating physician, and certain employee protections against discrimination. Now, currently, the Labor Code requires 9 categories of information that must be included on that posted notice. This bill, AB 1870, adds a 10th category to that list. Specifically, the posted notice must now also include that the injured employee may consult a licensed attorney to advise them on their rights under workers' compensation laws. In most instances, attorney's fees will be paid from an injured employee's recovery. That's pretty straightforward and will be included on that workers' comp notice going forward.
Great.
And,
Sorry to cut you off there, Yaron.
no, I was actually just going to hand it over to you, Anthony. So
Okay. So you know what, before we've got this slide about a few key dates, but that pretty much wraps it up for the new laws, the key laws. We've got some great questions coming in, and I'd like to throw some of these questions to Ann, Yaron, and I'll help with them too. They're actually really good questions. Yaron, going back to AB 1815, the question is, can you still require long hair to be pulled back or short haircuts for men? And generally, like, what on the grooming standards, what should employers be looking at in that context? And let me go back to that slide. The AB 1815, prior, I think it was in 2023, it was passed about the hairstyles prohibiting the discrimination based on these protected hairstyles, and I was just kind of fine tuning what employers could could not discriminate against based on hairstyles. But in terms of like health, though, in terms of working in a kitchen, the health standards are still applicable, and if they're reasonably related to, those health standards or the safety of the employees, yeah, requiring people to wear hair nets, pull their hair back, things like that would be generally okay. But it is something that, you need to be aware of, and how you're going about these requests. Make sure you thought through that request to say, like, this is why we have this practice or policy in place. Yeah, any thoughts on that, Yaron?
No, that's precisely it. I think you hit on it. Health and safety, specific to what's being done in the workplace, is going to trump all. And so the best practices is to ensure that the health and safety of the employee and the workplace are being considered. And so that's where you're not going to the hairstyles themselves, where wearing a hat or a hairnet or something like that allows it to be protected. But what you are not doing is, or what you should avoid doing, is a policy that prevents an employee from maintaining that hairstyle that now is being tied to race-based characteristic, and you don't want to, or you want to avoid any sign of discrimination that favors or impacts one group over another, especially when it can be resolved. The issue that you have with that particular hairstyle can be resolved through what I'll term like an accommodation.
Yep. And any other thoughts on that?
I think that safety and health issue becomes, it becomes paramount, and that's not a discriminatory act when you're doing things for the health and safety purposes.
Yep. And in terms of like requiring a short haircut, that's I think getting more problematic when you start dictating certain types of styles. Now, could there be a case where you could make that requirement? Say your restaurant or your business, is that's the image, potentially, but I'd be very careful going that route. And there still needs to be reasonable accommodations for employees as well. So for, again, health, religious reasons, things like that. But once you start, like Yaron mentioned, asking employees to change hairstyles, something permanent as opposed to just putting their hair back in a hairnet, something like that, I think that becomes more problematic, and employers need to look at that carefully. Yep.
Anthony, if I can just jump on real quick, when we're just talking about, asking employees to, cut their hair or make it short, you want to be careful that we're not so focused just on the race, but then you look at the gender issue. So if you're going to have, short hair for image or branding or whatnot, now you have to be cognizant of, does that short hair apply to all your employees because of this brand or image, or just the male employees? And you then butt up against another potential issue, which is still discrimination, but now we're shifting away from race, and now we're looking at gender and sex. So again, these are things that need to be looked at carefully.
Yep. Good question, though. In terms of the AB 2499 that I covered, and I have the wrong slide up here, the victims of violence and the leave that's permitted to them. The question is there any recourse against an employee if it becomes, can the employer take any recourse against the employee if the employee is abusing it, taking a lot of ongoing, and it becomes an ongoing attendance problem? Now, if it fits one of these definitions that I discussed here under AB 2499, it becomes, you need to be very careful about that. Now, if it becomes habitual, where and going for a long period of time, that's something an employer could take a look at. My final point here on this slide, and I didn't mention it when I was covering the new law, is employers have to provide a reasonable accommodation for employees' safety at work and as well for these leaves. If they use up all of their paid leave and they're asking for more leave, and it's a qualifying leave, that's protected. You need to give it, but employers need to be looking at to what can they be doing at the workplace, reasonable accommodations to provide for the employee's safety at work as well. So what measures they need to be taking at work to protect the employees. And that may allow the employee to return to work if you provide those reasonable accommodations. Now, if it's if it's just fits one of the definitions that I discussed, it's a qualifying leave. The employee has to go to court to testify or prosecute a case. That's protected leave, and it needs to be provided to the employee. So there is no time limit on that if it qualifies for one of these leaves, though. So, yeah, good question. We have a lot coming in. Let me see. Any other questions you guys would like to address before we move on? Okay. So just a few key dates, and we'll see if we have time. We'll circle back at the end here to answer a few other questions. Few key dates, reminders in 2025. January 1st, the state minimum wage increase, and we're keeping an eye on the minimum wage bill as well. But right now, it currently is set to increase to $16.50 an hour. And then for the Fast Food Act under AB 1228, and I've got a slide on this, we're watching the council, the Fast Food Council, to see what the, it's likely there's going to be an increase on the $20 minimum wage for the fast food industry, but how much? And the council had their meeting on September 12th, but there is no announcement yet. I checked the news this morning, still haven't seen anything, but they have the right to increase the rate by 3.5% or the rate of inflation. So we'll keep an eye on that to see what happens for the fast food industry. And then the city of San Diego has the minimum wage increase coming up here on January 1st as well as West Hollywood. And then just planning ahead into the year, May 14th, the California pay data reports are due for employers with 100 or more employees. It's always set now the second Wednesday of May of each year going forward. So May 14th is the deadline for that in 2025. We do recommend that employers that have this obligation get on that early. We've had issues where the website where you're supposed to submit all this data crashes. Everybody's doing it the last day, and that causes the employer to be late. So I recommend getting on that and compiling the pay data reports as soon as possible. And then July 1st, we've got the many local city and county minimum wage increases across the state. So I've got those listed out here. And again, we will make the slides available. So just jumping into it quick, I know we are running out of time here quickly, but just some cases we're keeping our eye on and a few reminders that these create for employers here in California. So the first case I wanted to mention, we've had our eye on this for a long time. I think we were talking about this at the end of 2023, actually. I think it was still pending before the California Supreme Court. It's the Home Depot case. So it's fully briefed. We're waiting for a decision. Could occur at any point here. But the issue here is, can California employers use neutral time rounding practices to calculate employees' work time for payroll purposes? Up until this case, it's generally been permitted. The leading case on this was a See's Candy case that allowed neutral time rounding policies to be used by employers. But we've seen recently, the last couple of years, there was a case in the Donahue case, the California Supreme Court said, you know what, for purposes of meal breaks, taking the 30-minute meal break, employers are not permitted to use time rounding policies for that. So it needs to be a full 30 minutes, and the employers need to track minute by minute for the 30-minute meal break. And that's why I'm going out on a limb here with my prediction on this slide that I have a strong feeling the California Supreme Court will hold that time rounding is not permissible under California law. And going back to that Donahue decision involving the 30-minute meal breaks, the court really got into like, look, with the use of technology today, there's no reason the employers can't track actual time for the employee versus we had the employees recording it on a piece of paper in the past where it was easier to round and you didn't have computers able to do the calculations easily. In that Donahue case, it was pretty clear the California Supreme Court said, look, we don't see why employers shouldn't be able to just track the time to the minute and pay it to the minute. So that's my prediction on that case. We'll keep an eye on that. But just, the fact that the Donahue decision came out for the 30-minute meal break saying you can't round for that, we are recommending that employers move away from time rounding, and we expect this case to go against allowing employers to time round the time for employees going forward. But definitely keep an eye on that. These next, I think, couple of cases are discussing arbitration, the use of arbitration agreements in the workplace. We are still big proponents of utilizing arbitration agreements where employers can build in class action waivers into the arbitration agreements. And I'll talk about this here in a little more in detail in a couple of minutes. Under California law, we can't have the employee waive their right to bring the Private Attorney General's Act claim, PAGA claims, but we can have the employees waive their right to bring class actions. It's still a very valuable tool for California employers. And any employers with any sizable employees, if you've got more than 50 employees, it's something you should take a look at, the use of these arbitration agreements and still building in the class action waivers. So this one here, in this case, pretty fact specific. I won't get into the details of the case, but it's being challenged. This was a mandatory arbitration agreement that the employee had to sign, and whether it was unconscionable, whether it was too overreaching in terms of the benefits that the employer was getting through this arbitration agreement. So we are recommending that employers present these arbitration agreements to employees voluntary and having very clear and fair terms in those agreements so that they are enforceable. And the fact that we do recommend that they are voluntary helps enforce the agreements. It prevents these types of arguments that are being raised in this Fuentes case as well. So something to think about. If you don't have an arbitration agreement in place, definitely reach out to us, talk to us about it. There are pros and cons. It's not a silver bullet by any means, but it is something larger employers should be taking a serious look at. In this case, another arbitration case, we've got a new law, relatively new law that was passed in California saying, look, if the employer's got an arbitration agreement and the employee files a lawsuit and the employer takes the case to arbitration, either brings a motion to compel arbitration or the employee voluntarily goes to arbitration, and you're in arbitration and the arbitrator submits the bill to the employer for their fees, it needs to be paid by the deadline set by the arbitrator. And if the employer does not pay by that deadline, the case is kicked out of arbitration and goes back to civil court, and the employee has all rights under the civil action to proceed under the civil case. So in this case here, the employer is arguing that federal law preempts the state law, saying that the employer has to make that payment to the arbitrator in the time set by the arbitrator. And oftentimes it's very quick, within 30 days. And if you miss that, you lose the right to stay in arbitration. So there's an argument here being made that the Federal Arbitration Act, the FAA, preempts state law on this issue. And we'll see what the California Supreme Court says. And it's likely the U.S. Supreme Court will probably be at least asked to chime in on this issue as well. So we'll keep an eye on that. But right now, the takeaway, though, is if you're in arbitration, your lawyer needs to be making those payments to the arbitrator extremely timely. And if you miss that deadline, it creates major problems for you to continue in arbitration. So that's the current law. And yeah, but we'll keep our eye on that going forward. In this case, this wage and hour case, it's been pending in front of the California Supreme Court for a while now. It's fully briefed. We're waiting for a decision. It gets a little technical on what's being litigated here, but we're going to get some clarification on what the employer's good faith defense is to avoid liquidated damages in a wage and hour claim. So when the employer is saying, look, I tried my best to comply with the labor code, and the employee is not entitled to extra liquidated damages, which are the amount of unpaid wages. So it basically doubles their damages. So they get their unpaid minimum wages plus this liquidated damages. The employers do have this argument, like, well, I was good faith trying to comply with the labor code. The liquidated damages provision should not apply. We'll get some clarification, hopefully, on what the employer needs to be doing to have that defense. And also here in this case, we'll be tracking the issue of whether a plaintiff has a private right of action to sue for paid sick leave under the Healthy Workplaces, Healthy Families Act of 2014. So that'll be an interesting issue. We're keeping an eye on that. And then in this last case, Zhang versus SC Dentons, very detailed. Again, don't want to get into the facts. A partner left a law firm, and there was a dispute over some attorney's fees and payment. But the law firm had an agreement with their employee saying we had agreed to try this case not in California. So if the employee brings a lawsuit, we're going to go to, I think it was New York in this case, and have this other jurisdiction hear the case. As a reminder, California Labor Code Section 925, and I've got this next slide, prohibits employers on making giving an agreement to an employee with a forum selection clause and making it a condition of employment to adjudicate claims outside of California that arose in California. And then as the Labor Code Section 925 puts it, deprive the employee of the protection of California law. So it's a case we're keeping an eye on the whether these are enforceable, and then really too, if a case is brought outside of California, what rights do the courts here in California have to continue to litigate the case if this case is proceeding in basically two jurisdictions. So just a reminder here for the employers on the call, Section 925 does not apply to any contracts negotiated when the employee is represented by legal counsel, and it does not apply to any severance agreements since that's voluntary and it's not a condition of employment. So employers can still have these choice of law and choice of venue claims included in severance agreements, but get some advice on that. It gets tricky, as we're seeing in this case going up to the California Supreme Court. So yeah, but it's just a good reminder to look at those severance agreements. If you haven't updated severance agreements or employment agreements with your employees, take a look at it. It's changing quickly on these different requirements. And in your own, before I get into a quick review of PAGA, anywhere else we should circle back on any other questions, or should I just continue with the PAGA reform?
Real quick, somebody asked about the voting requirements, and it's that time of the year too. So yes, if an employee doesn't have sufficient time outside of working hours, their scheduled working hours to vote, they are entitled to take up to 2 hours paid. And if more time is needed, depending on the location of their voting location, that would be unpaid. An employer can require the employee to take the time off at the beginning or the end of the shift, whichever is going to allow for more working time. And also they can require that the employee give notice of their request to take time off. I believe it is 2 working days prior to the election.
Great. Yep, I'm sure that's on everybody's mind. So instead of going over PAGA, we've done a webinar on that and have a lot of resources on that. I know we've got a few minutes left here. I just want to do a quick review of 2024, some reminders for California employers. And as we all know, we had AB 1228 pass here in 2024, increases the minimum wage to $20 per hour for the fast food industry. Again, the Fast Food Council is looking at that, and each year, January 1st, that rate will go up. We're keeping an eye on that, but also as a reminder, keep an eye on the salary threshold required for exempt employees working in the fast food industry. So currently in 2024 here, the minimum salary required is $83,200. That will be going up as they increase the minimum wage here on January 1st. So take a look at that. And we don't have any announcements on how much is going to increase, but we'll keep an eye on it, as everybody on the webinar should as well. For the indoor heat illness, I'm going to hand that over to Yaron.
Sure. I know we are limited on time, so we'll just keep it brief. This comes as no surprise. The Calos's indoor heat illness prevention regulations went into effect mid-year, July 23, 2024. And effectively, it applies to most indoor workplaces, such as restaurants, warehouses, and manufacturing facilities where temperatures can get high. For indoor workplaces where the temperature reaches 82 degrees Fahrenheit or greater, employees must take steps to protect workers from heat illness. So key points, these regulations require providing access to clean drinking water. And what that means is, fresh, suitably cool, and free of charge, located as close as possible to the work areas and cool down areas. Provide access to cool down areas. These are areas that must be kept at a temperature below 82 degrees Fahrenheit and shielded from high radiant heat sources. Provide cool down rest periods. So again, encouraging workers to take preventative cool down rest periods. Think of them as rest breaks. These are, in addition to your California required 10-minute rest break for every 4 hours worked or major fraction thereof. This is a separate but also paid rest break, considered called a recovery period or cool down rest period, and they are a minimum of 5 minutes. But encourage workers to take those, or if a worker is suffering from symptoms of heat illness or feels like they need that and they make that request, they are entitled to that minimum 5-minute recovery period. Employers, I'm sorry?
Sorry to interrupt.
Sure.
Go ahead.
Oh, okay. Further requirements are providing an assessment and control measures. And what we're talking about here are, engineering controls and administrative controls to reduce heat illness. So engineering controls would be things like increasing natural ventilation, cooling fans, air conditioning, using exhaust fans in high heat source areas. Administrative controls are things like rotating employees, rescheduling work, reducing work intensity to minimize heat-related illness, those kinds of things. And then ultimately, and each of these controls are intended to minimize the effects of heat illness. If engineering controls are ineffective or not feasible, and administrative controls are ineffective or not feasible, then the third option is looking at what we call personal heat protective equipment. So these would be things like vests with ice packs or uniforms that wick away sweat and allow ventilation, or portable battery-powered fans. So those are just some examples. Additional requirements are monitoring weather and temperature, having emergency response procedures, observing new workers during what we call the acclimatization period. Acclimatization means temporary adaptation of the body to work in the heat that occurs gradually when a person is exposed to it. And so the peak of this acclimatization in most people is within 4 to 14 days of regular work for at least 2 hours per day in the heat. So an employee who has been newly assigned to a high heat area, or a new employee, needs to be closely observed by a supervisor or designee for the first 14 days of their employment in that area. That's what we call the acclimatization period. Employees need to train their employees, both supervisory and non-supervisory, regarding these topics. And then lastly, you need to establish, implement, and maintain an effective written indoor heat illness prevention plan. And fortunately, Cal OSHA provides a model plan that is available on their website, and it is a template that can be used and must be modified, though,
Right.
specific to the employer.
And this requirement went into what, it was July or August, right?
Yes, correct. July 23rd, 2024.
Okay, so that's in place. Important to pay attention to that. And as a reminder, at the beginning of 2024, we had the SB 476 for the food handler bill. Employers are required to pay for the cost of training and for the time for the training and to attain the certification, which is approximately 2.5 hours. I've got some reminders on that here on this slide as well. We will make these slides available. And we'll wrap it up here with Anne on the reminder about the July 1st workplace violence prevention plans.
Yes, I'll get this under a minute here. July 1, 2024 was the deadline for all pretty much all California employers to have in place the new workplace violence prevention program. If you have not got that in place, I highly recommend start doing it now. You're to have a plan document that's available on the Cal OSHA website. You can use that. You're to provide training, record workplace violence incidences, and many other types of records. Again, the deadline has already passed. How do you get started? What do you do? First thing you should do, Anthony, we can move on to that next slide, is designate someone who is responsible for implementing this plan. Number 2, outline how employees can report the incidents or threats of violence. Number 3, detailed how the company will identify and correct workplace hazards. 4, create procedures for responding to emergencies. 5, identify how to develop and provide training. And 6, very importantly, use Cal OSHA's model plan. Your plan should be, if you have multiple locations, you do have to have multiple, it can be the same plan, but specific information to the location, like specific hazards and contact information of how employees obtain a copy of the plan or who to report to. Those need to be customized to each location. And also, this is a good time. You're also required by Cal OSHA to have in place a written injury illness prevention plan. That model plan is also on Cal OSHA's website. Make sure you have both in place. If Cal OSHA ever comes out to visit your location, it's one of the first things they're going to ask for. And if you don't have that, most likely you can expect a citation.